This recent decision of the Supreme Court has attracted a lot of interest and commentaries on contemporary laws of self-defense and the issue of farmer-herder conflict in Nigeria. Decided by a panel of 5 in March 2025, is the case of Sunday Jackson and the state. This is the background story. On 27th of January 2015, in a bush within the village area of Kodomti in Numan local government area of Adamawa state, Sunday Jackson was said to have killed one Adamawa by stabbing him on the neck 3 times. In this case story, I will refer to Sunday Jackson as the appellant, Adamawa as the deceased, and the state as the respondent. The appellant was arraigned on a one-count charge of culpable homicide punishable with death under the Penal Code laws of Adamawa State. Now, culpable homicide punishable with death, as you find it in the Penal Code laws of the Northern States, is the same as the offense of murder, as you find it in the Criminal Code laws of the Southern States. During trial, the prosecution called 2 witnesses in proving the charge against the appellant and tendered exhibits, part of which were the confessional statement of the appellant and a coroner report on the death of the deceased. According to the appellant, the deceased had attacked him while touching grasses in the bush after losing sight on some persons he alleged had killed his cattle. The deceased, out of frustration after losing sight on the person he was pursuing, attacked the appellant and stabbed him with a dagger. In a struggle that ensued out of this, the appellant seized the dagger from the deceased and stabbed him on the neck 3 times, leading to his death. In the testimony of the appellant in his defense, he testified that he was working on his farm when the deceased approached him and inquired about some persons. When he denied seeing them, the deceased drove his cattle into his farm to graze. When he attempted to chase the cattle away, the deceased attacked him with a dagger. The appellant claimed he ran and shouted for help, but the deceased stabbed him on the back of his neck and on his left leg. During the struggle, the appellant managed to seize the dagger from the deceased, who then picked up a stick. Then he stabbed him 3 times on his neck, which led to his death. According to the appellant, he was merely acting in self-defense and the reaction was necessary to protect his own life. But the trial court rejected the plea of self-defense and convicted the appellant, sentencing him to death by hanging. On appeal, the Court of Appeal affirmed the conviction and sentencing of the appellant. Dissatisfied, he appealed to the Supreme Court. In the appeal, the Supreme Court had to decide whether the plea of self-defense, which is exculpatory, or defense of provocation, which is mitigatory, would avail the appellant. Now, by exculpatory, we mean that if the defense is successfully pleaded, the appellant will have been deemed under the law to have committed no crime, while the defense of provocation, which is mitigatory, would amount to the court mitigating the punishment of the appellant, reducing it from death by hanging to life imprisonment. In a 4-1 majority decision of the Supreme Court, the Supreme Court held that the defense of provocation and a plea of self-defense are mutually exclusive, in the sense that the two of them cannot coexist in defense of a particular person. That is to say, you cannot claim to have unalived a person because you were angered in one breath, and in the other claim that your actions were necessary to protect your own life. The Supreme Court proceeded to elaborate on the issue of self-defense thus. For a successful plea of self-defense, the following conditions must coexist. 1. That the accused must be free from fault in bringing about the encounter. 2nd, there must be present an impending peril to life or of great bodily harm, either real or apparent, as to create a honest belief of an existing necessity. 3rd, there must be no safe or reasonable mode of escape by retreat. And 4th, there must have been a necessity for taking life. Further, in expounding on the issue of necessity in self-defense, the Supreme Court stated that under our legal system, If a man is attacked in circumstances where he seriously believes his life was in danger of serious bodily harm, he may use such force as he believes is necessary to prevent and resist the attack. And if in using such force he kills his assailant, he is not guilty of any crime, even if the killing was intentional. In deciding whether it was reasonably necessary to have used such force as was used, regard must be had to all the circumstances of the case, including the possibility of retreating without danger or yielding anything that he is entitled to protect. In essence, the Supreme Court is saying that if the situation still allows you to retreat or escape without losing your life, your loved ones, or your valuables to the assailant, there is no necessity to take a life. If you are thinking the Supreme Court should have returned a different verdict considering the peculiarity of this case, you are not alone. Because out of the panel of 5 that sat on this appeal, a respectable justice of the Supreme Court dissented. Honorable Justice Ogunwumiji was of the views that the plea of self-defense should have availed the appellant considering the facts and the circumstances of this case. And this is the end of this case review. I want to know your comment about this decision and the facts of this case. And until I come your way for another one, I remain Oluwagbemiga Alana. Thank you.